On June 18th, 2024, President Biden issued an executive order saying basically that U.S. citizens who have undocumented spouses and children may be able to now petition for their undocumented spouse and children and be able to allow them to parole in place and apply for their green card without leaving the United States. In this podcast, hi, I'm Hillary Walsh. I'm your immigration attorney friend. I want to simplify and really kind of explain as much as we know about what this executive order means, who qualifies for it, and kind of what the next steps will likely be. Number one, I want to share that you should definitely talk to an immigration lawyer right away. We've already had clients hire us for this process. So at New Frontier Immigration Law, we are familiar with what we need to do to the best of our ability. Immigration law changes all the time, just like this change came out just a few days ago. And then we won't be able to actually apply for the process until later this summer when there's more information about it available. But let's dive into kind of who qualifies and things like that. If you are listening to the podcast, just know that I'm also recording this and this is available on YouTube. So when you're hearing me describe different things and that we're looking at them, please know that if you want to see what I'm talking about, you can come on to New Frontier Immigration Law's YouTube page and check it out. But what I want to show you and share with you is just the executive order itself that really goes over kind of what Biden is talking about. And it gives us as immigration lawyers some insight on what the process is going to be able to help what Biden is calling keep American families together. Now, from a 30,000 foot view, you may have heard about this process before in a different context. Parole in place, and that's what this is essentially. I mean, it's just a different term for it. It's just a different title put on the outside of the box. But it's parole in place where you're allowed to, even if you entered the country without permission, you're allowed to do the process here in the US without leaving. And what this process will do is that it's going to allow you to shave off needing a 601A waiver, which takes many, many years. It's like over a 3-year wait right now for a 601A waiver. And then you have to leave the country and go to your home country's consulate, which is called consular processing. And overall, that total process takes about 5 years for Mexicans. It can vary for Canadians. It can vary for, UK citizens, et cetera. But the main client base that I serve is Mexicans, Guatemalans, and other Central Americans. And Mexicans in particular have a very long wait. It's about a 5 to 6 year process. If you go through the process for a 601A, you wait for that to be granted, and then you start the process with the consulate. That takes a couple of years. And overall, and that's after you've gotten your I-130 approved. Overall, it can take about 6 years. This is going to cut off almost all of those steps and instead allow you to apply for parole in place, which says even though you entered the country without permission, because you meet these certain criterion, we're going to allow you to apply for your green card without needing a 601A and be able to just do the whole process here. And you don't have to leave and go to your home country for your consulate, for the consular processing there, which is super cool and is very helpful. And it's a process we're familiar with as immigration lawyers because of the military parole in place option that already exists. And I want to tell you a little bit about that. Now, I've done a lot of military parole in place because my husband is a U.S. Air Force pilot and he has been for like 20 years. And so I have lots of friends who are in the military and we've done a parole in place process for their spouses. And then, of course, I've done it for lots of our clients here in Arizona and for other states. So what the parole in process place does for military families is if you are a veteran, like you were in the military and you were honorably discharged, so you got out of the military and everything was all good, you weren't kicked out, you're allowed to petition for your parents, for your spouse, or for your children because you were a military member. And this is kind of like a nice benefit that we give to people in the United States who served in the military. And it also works for you if you are still actively in the military. So if you're a veteran or you're actively in the military, you're allowed to do what's called parole in place. This is wonderful. Biden is essentially expanding that parole in place option, which I will say Trump said during his presidency that he was actually wanting to get rid of the military parole in place option. So That's interesting. Biden is actually expanding this to say it doesn't matter if you're a US citizen, it doesn't matter if you were in the military or not. We're going to allow you to apply for your spouse and your children if they're undocumented and they meet these other requirements. And now I'm going to show you kind of where I'm getting these requirements. If you're listening, don't worry, it's just a paragraph. You can Google it and you'll see what I'm talking about. But this executive order from Biden, like this press release that they have, is talking about in order to be eligible, the non-citizen has to have resided in the US for 10 years or more as of June 17th, 2024. So you'll have to have lived here in the US since June 17th, 2014. Let's stop there, full stop. In almost every other, like we don't have a whole lot of information about like, what if I left for a brief amount of time and came right back? What if I was deported and came right back? And I was only gone for like, maybe it was just a matter of hours because I returned right away. We don't have a whole lot of information because it doesn't answer those questions in this press release. We will find out more later. But what I will say is that in every other area of the law, we always have to prove 10 years of continuous physical presence. And one of the questions you may have is, how can I do that? And I want to answer that right now. Ways that you can do that in any other context related to 10 years of continuous physical presence are things like housing records. Did you pay rent? Did you have a mortgage? Did you have an apartment? Did you have a water bill? Anything that shows that you've been here for maybe you have one from 5 years ago and that puts you on the map here in the US. Maybe it's right here in Phoenix 5 years ago. And then you also have your marriage certificate from 5 years before that. That puts you on the map 5 years before that. So we have two pieces of evidence that show at least 2 points in time that you were here for 10 years. Let's fill in more of the gaps. Maybe you got speeding tickets. Maybe you went to college. Maybe you got a COVID vaccine or had to go to the doctor for something else. Maybe you're the main point of contact listed for your children's elementary or middle or high school, showing that you're going to parent-teacher conferences. Maybe you applied for a driver's license, or perhaps you've been working for the past 10 years and you have pay stubs showing that you've been here for 10 years. Maybe you have, and mind you, all these things don't have to show the entire 10 years with one piece of evidence. When we look at this as immigration lawyers, we just have to show that you're basically here, putting you on the map, like little chart, like little points on the map for that 10-year timeline. So all of these things can be like, well, this shows that I was here going to college for 2 years. Perfect. That covers those 2 years. Let's look at these other things and we kind of piece them together like pieces of a 10-year puzzle. So don't worry if one piece of evidence doesn't cover everything, okay? Cell phone bills are a really easy way to show, and even cell phone usage shows that you're here in the US because we have access to those. In the past 10 years, that technology is pretty available to us. So those are all various ways, and there are lots more. So if you don't have all of those things, don't worry. As immigration lawyers, we can help you kind of solve this problem, this evidence problem, because if I were you and I was thinking, wow, I think I qualify for this, the first thing I would start doing is, number one, I would call us so we can tell you. I can help you whether you're in Rhode Island, I can help you whether you're in California or anywhere in between, okay? So you can give us a call and we'll let you know if we think that you qualify, and we'll move forward from there. And then we can tell you what evidence we believe that you'll need. But if you're wanting to do this yourself, and immigration law is just like your taxes, you don't have to hire a CPA, you don't have to hire a tax person, and you don't have to hire a lawyer to help you do these processes. So if you want to go at it yourself, or at least start preparing things yourself, then one of the things that I would do is start gathering this 10 years of evidence. And it can be medical records, school records, etc., church records. Maybe one of your children got baptized. Like, there's so many different things that show you were here in the US, and you're going to want to gather those things. So start gathering the evidence now. So that kind of addresses the first part of this, the set of rules that show whether or not you're eligible to apply for this spousal US citizen spousal parole in place. That's what I'm going to call it. Okay. So that you have to have lived in the United States for 10 or more years. So we have to show at least the 10-year point. If I were you, I would talk about if you've lived here for 23 years, and that's what Biden is saying, the average person has lived here for 23 years who's going to be eligible for this. That's wonderful because you can talk about how you've been here for so long. If I were you, I would, get my FBI fingerprints done so that I can show I have no criminal history. That's also going to show, maybe that not only you've been here, but that you have no criminal history. But you also have to show that you're legally married to a U.S. citizen. So while satisfying all these other applicable legal requirements, you have to have resided in the United States for 10 or more years and be legally married to a U.S. citizen as of June 17th, 2024. So all of you who got married on June 18th, 2024, at this time, from what they're describing, you will not be eligible. You will have to have been married as of June 17th, 2024. So don't worry if you're not married, if you got some other things going on, you could still be eligible for the 601A and the consular processing, among many other things. So this doesn't mean, basically, like, if you're eligible for this process, that means you were also eligible for a 601A and a consular process. Like, this doesn't cut off anything. If you're not eligible for this, it just means you have to go the longer path. That's all it means, which sucks. And I wish that that weren't the case. But if you do qualify, you were married to a U.S. citizen, not a lawful permanent resident. You were married to a U.S. citizen on June 17th, and you've been in the United States for at least 10 years as of June 17th, 2024, then you kind of check the initial two boxes. Now, it also says that in this press release, it also says that you have to satisfy all other applicable legal requirements. And that's where I believe that this is not going to help you if you have the permanent bar. This is the same rule with the military parole in place process. Okay. So if you have the permanent bar, which means you left the country, you were here in the country for more than a year without permission, you left and you came back illegally without permission again, and you did that all after April 1st, 1997, then you're going to have what's called the permanent bar, or in immigration law, what we call the C bar. Okay. Like the letter C. And this means that you're not able to fix your status without some other type of issues going on. Like we would have to look at doing a VAWA process for you, a U visa or a T visa, in order to help you fix your status. So I'm going to kind of stop there on that explanation, because there are so many different things that you have to, this satisfying all applicable legal requirements in order to be eligible basically means you still have to be eligible for a green card. They're just going to basically forgive the fact that you entered illegally. That's really what this is forgiving. It's like saying, you know what? We're going to forgive the fact that you entered illegally. We're going to allow you to parole in place, which means essentially we're going to grant you an entry document here in the United States, and then now you can apply for a green card, and you need to do it within 3 years, and we're going to give you a work permit while you wait. So a lot of great benefits. This is almost mirrors identically the military parole in place process, which is great because that means that USCIS is used to processing these. And, as immigration lawyers, we already basically know how to do this because we've kind of done it before with its cousin, the military parole in place process. Now, here's what I will say is it applies to married couples. So if you're in the process of getting a divorce, or you have been divorced, from what I'm seeing here, this is not going to help you. However, a VAWA process could help you. Maybe you've never gotten married, or maybe you've gotten married, in the last week since this has been released. Okay, again, maybe a VAWA process would be good for you so that you don't have to consular process and do the waiver. Or what if you've never gotten married, or the person you're married to isn't a U.S. citizen? Maybe they're a lawful permanent resident, or maybe they have no status. Again, you still have lots of options like a T visa and a U visa, including asylum. That might be a great option for you as well. But all this is to say, if you had, this really is how I want to land this plane. If you had the opportunity to consular process through a 601A waiver, this is going to be a process that just helps you fix without leaving. And that's pretty cool. You have to, however, have met a few of these extra requirements. You can have been married to consular process with a 601A waiver. You can have been married for 1 hour. Okay. And then you can file for those things. With this, in order to bypass and, pass go, collect $200 and do your whole process here in the US, you're going to have to have been married for 10 years. I'm sorry, have been here in the United States for 10 years, and you have to be legally married to a US citizen. So it's not a complete, everybody who's here and is eligible for consular processing, you can go ahead and fix. It's really for a very discrete group of people who've been here for a long time and their children who are also undocumented. So this is really exciting. It's on one hand, it's kind of like groundbreaking because we haven't seen a lot of immigration reform or a lot of executive orders work. A lot of them have just been tied up in litigation. We've seen DACA, for example, just basically get crucified, and it's no longer really an eligible or thing that as immigration lawyers we encourage people to even apply for anymore. We just have you renew if you have DACA to begin with. But this gives me a lot of hope. I hope that it doesn't get tied up in federal litigation. I hope that a temporary restraining order doesn't come to pass, just like it did for DACA, which completely halted everything during the Trump administration, and the Biden administration hasn't been able to get it revived. I really hope that's not the case here. But what I will say is call us. The only way to know if this is going to work is if you apply. And the only way to know if you qualify is to call and talk to an immigration lawyer, or like we're doing, reading this executive order as carefully as possible. I hope this is helpful. I hope it gives you some light at the end of the tunnel. If you were looking at, wow, I really can't afford, like for a lot of families, consular processing is not a viable option. It really isn't, because it means separating the family for potentially a long time. And it's very scary for people to have to go through that, especially if you're the primary caretaker or the primary income earner for your family or breadwinner. That can be really hard for people. So this spousal parole in place option may be really great for you so that you can fix without leaving and get through the process relatively quickly. Go from basically a 6-year process to what I will predict is going to be an 18-month process, is what I would guess is probably going to be in the end. Let me know if you need any help. I am always here for you, my friend, and I hope you have a great day. Share this with a friend if you think this is helpful for them. And if you do have the permanent bar where someone's told you have to leave the country for 10 years in order to fix, I really encourage you to still contact us, because even with military family members, where the family member of the military active duty member, they have the permanent bar, there's something called parole in place deferred action, which is essentially like DACA for people who can't apply for the green card. And my guess, it is at this point, it is totally just a guess. My guess is that something like that will also be made available for people who have the permanent bar as well. So don't lose all hope. And we have things like T visas, VAWA, and asylum, and all this other stuff available to you all the time anyway. None of that has changed. This has just added another entree to the buffet menu, if you will. Have a wonderful day, my friends. Share this with someone and give them some hope. And tune back in for another episode of Immigration Law Made Easy. Bye, friends.